During your trial here in New York, you are getting frustrated, you are getting upset, you are getting angry. You think that the judge is out to get you. You think that the judge is against your attorney and he hates your attorney and he hates your case. What can you do in that instance? And more importantly, is that really the perception that you get from this case, from this trial, from this judge? You want to know what this is all about? Come join me on this walk as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, it's a beautiful day today and I had a few minutes to share this great information with you. Let's say you brought a lawsuit against your careless doctor, and now, after 2.5 years, your case goes all the way to trial. The doctor whom you have sued denies all of your allegations. Great. So now, during the course of trial, your attorney is trying to get in certain information so the jury can hear it. He's trying to show certain photographs so the jury can see it. He wants to bring in certain witnesses out of order so the jury can hear their testimony because of a scheduling conflict. In almost every single request or every single attempt that your attorney is making to get certain information or documents or evidence before the jury, the defense lawyer is objecting. Now, the defense lawyer has a right, a legal right, to object to certain evidence, to certain questions, to certain information, to things that are going on at trial. The defense lawyer has that obligation on behalf of his client to go ahead and do that. And now the judge has to make an immediate ruling. He makes a snap decision about whether or not he agrees with the defense lawyer or whether he disagrees. If your attorney is trying to get in a certain photograph into evidence, or he wants to show the jury a certain document, now the defense attorney is objecting and he gives the judge a specific legal reason why this particular document or this photograph should not be admitted into evidence. The judge turns around and immediately says, "Yes, defense lawyer, I agree with you. This document should not be admitted into evidence." And now your attorney is getting frustrated. He's getting upset because he really feels that the jury needs to see this photograph. Your perception every time the judge makes a ruling against you is that the judge doesn't like your attorney. You perceive that the judge doesn't like your case. You think the judge hates you and your case, and you think the judge is being totally unfair and that he is biased. During a break, you turn to your attorney and say, "This judge is outrageous. He hasn't made one single ruling in our favor. I think he's totally biased and prejudiced. I want him off our case." You tell your attorney you want him to do something about it. Your attorney says to ask for a mistrial this far into the case, claiming that the judge is biased, isn't going to get us anywhere. The judge is not biased. The judge is not prejudiced. Although he's making rulings against us repeatedly, he has a good basis to do so. There are legal problems with certain information I'm trying to get in front of the jury, and I know it. I know that I shouldn't be talking about this particular topic. The judge has told us not to talk about it in chambers. I know that this document really shouldn't be coming into evidence, but I want the jury to try and hear about it and learn about it. So although the judge is making rulings that appear to be against us, he's actually not biased. He's not prejudiced. And even if I were to make a request for a mistrial and ask for a new judge, he likely would not allow it. So, although you perceive that the judge is against us, you perceive that the case is going against us because I can't get certain information in front of the jury, does not necessarily mean that your case is going downhill. It does not necessarily mean that you are going to lose your case. There are many instances during the course of a trial where you will have what we call highs and lows. There will be certain days where you feel great and you feel on top of the world and that your case is going terrific and that everything is going against the defense. There are other days when you will be at a very low point and you will think that everything is going against you, that the judge is always ruling against you, that there's no possible way you could come out of this winning this case. And then there are other days where you will feel terrific or somewhere in between. That's the reality of going to trial. And something else you should know. When you go to trial, it means that there are questions of fact that the jury has to decide. Your credibility is on the line. Did you know that? Did you know that, in fact, these trials are all about your credibility and your witnesses' credibility and your experts' credibility? If you are more believable than the defense, there is a good chance you will likely win your case. If, however, there are credibility problems, you've got a problem, my friend. The jury will have to decide whether you are slightly more likely right than wrong. And it's all based upon credibility. So why do I share this quick information with you? I share it with you just to give you a sense of what really happens during a trial involving medical malpractice cases, accident cases, wrongful death cases in New York. You know, I recognize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.